If this was useful, there's a lot more where it came from. Other specific situations, other specific rights, all covered with the same care we're putting into today's topic. Subscribing is the easiest way to make sure you don't miss the next one, especially since a lot of these topics tend to become relevant exactly when you least expect it, which is exactly why it's worth having them ready in advance rather than scrambling to look them up in the moment. All right, let's keep going with today's topic. There's a knock at your door. Not the kind of knock that belongs to a neighbor returning something they borrowed. Not the sound of someone who texted ahead. Not a delivery driver with a package you were already expecting. This knock has a different weight to it, a different rhythm, and when you move toward the peephole and look through it, what you see changes the entire temperature of the room. There's a badge. There's a uniform. Maybe there are 2 of them standing there, or 3, standing with that specific kind of stillness that doesn't belong to anyone making a casual visit. And in that exact second, before you've said a word, before you've decided whether to reach for the doorknob at all, your entire relationship with your own home is suddenly sitting at the center of a decision most people get completely wrong, not because they're reckless or uninformed, not because they don't care about their rights, but because no one ever sat them down and explained, clearly and specifically, what that door actually means from a legal standpoint, what it protects, how long that protection lasts, and exactly what makes it disappear. Here is what I want you to walk away from this video knowing so completely that it doesn't require any effort to remember it under pressure. Your home is the single most legally protected space in the entire framework of rights this country was built around. More protected than your car, more protected than your phone, more protected than the street you drive on or the sidewalk you walk along or the workplace you spend half your life in. The protection that surrounds your home under the Fourth Amendment sits at a level above almost everything else you encounter in daily life, and that level of protection exists for a specific, deliberate reason rooted in the founding of this country. And the moment you open that door without understanding what that protection is and exactly how it works, a significant portion of it can begin quietly slipping away, one small, seemingly harmless decision at a time, while you stand there thinking you're just being cooperative and reasonable and polite. If you want to actually understand this, not just have a vague sense that you have rights somewhere in this situation, but couldn't explain exactly what they are or how they work, subscribe right now, because that's the entire purpose of being here. And before we go further, one clear note: this is legal education and commentary, not legal advice for your specific individual situation. I want to be upfront about something, because I think it's important to say directly, rather than bury in a quick disclaimer. General legal education, including everything we do here, has real limits, and it's worth understanding exactly where those limits are. What we can do here is give you a strong, accurate, genuinely useful foundation, the kind of understanding that changes how you experience a real situation when it happens. What we can't do here is account for every specific variation, every local nuance, every unique detail of your particular circumstances, because that's simply not something general content is built to do, no matter how thorough it tries to be. That's exactly why the foundation matters so much, though. A strong general understanding is what tells you when a situation is straightforward enough to handle with what you already know, and when it's specific and serious enough that it's worth bringing in someone who can look at your exact circumstances directly. All right, keeping that framing in mind, let's get into it. And some of the details shift, depending on your state, but the core framework we're walking through holds up essentially everywhere in this country. Now let's actually get into it. Let's start at the very foundation, the single legal fact that every other piece of this conversation is built on top of, because without it, nothing else we cover will land the way it needs to. The Fourth Amendment to the Constitution protects people against unreasonable searches and seizures. That's the basic statement most people have heard at least a version of at some point in their lives, but the part that matters most specifically for what we're talking about today is this. Courts have consistently, repeatedly, across decades of decisions, treated the home as the place where Fourth Amendment protection reaches its absolute peak. Not somewhere in the middle of the scale, the top. The framers of this country had lived through a world where officials could enter homes essentially at will, conducting general searches with no real requirement to justify themselves to anyone, and they built a specific, deliberate wall against exactly that kind of intrusion. That wall still stands. It belongs to you whether you own your home or rent it, whether it's a house with a yard or a studio apartment on the 14th floor, whether officers arrive with marked cars and visible badges, or pull up quietly without any visible indication at all of who they are. And understanding that this wall exists, that it is yours, and that it only disappears through specific, legally defined circumstances is the foundation that everything else in this video is built on. So let's start with the very first moment. The moment the knock happens, before any words have been exchanged, before the door has moved even an inch. The first thing worth knowing is this, and it will probably feel counterintuitive if you've spent your life assuming that police knocking on your door means you have to engage. You are not required to open your door, not generally, not as a baseline legal obligation. There is no standard rule that says a knock from law enforcement creates a duty on your part to answer, any more than a ringing phone creates a duty to pick it up. You can look through the peephole, confirm what you're seeing, and simply choose not to open the door at all. And that choice is not illegal, is not obstruction of anything, and is not evidence of guilt or consciousness of guilt or anything else. It is simply a person choosing not to open their door, which is a thing people are allowed to do. I know this feels wrong to people who grew up absorbing the idea that you always cooperate with law enforcement, that refusing to engage is something only people who have something to hide would do. I'm going to spend a lot of time in this video addressing exactly that feeling, because it's the feeling most likely to talk you into doing something that costs you protections you're entitled to keep. But for right now, just hold on to the starting point. The door stays closed unless you decide otherwise, and that decision belongs to you. Now, there's a critical exception sitting underneath that general rule, and you need to understand it clearly, because this is where the actual complexity of this whole scenario lives, and where a lot of people's understanding gets fuzzy in exactly the ways that cost them the most. If officers have a warrant, the situation changes in meaningful ways, and I'm going to walk through exactly how it changes in a few minutes. But if they're knocking without a warrant, what they're doing is called, in legal terms, a knock and talk. They're hoping you'll open the door, start talking, maybe step outside, maybe invite them in, maybe give them something they couldn't have obtained any other way. And because everything about a knock and talk is based on your voluntary participation is something you are allowed to decline. Not partially, not after answering a few things first. All of it, beginning to end, if you choose, because voluntary means you get to decide how much of it actually happens on your end. Let's talk about what to do from the moment you hear that knock, step by step, in a sequence you can actually rehearse right now, so it's not something you're inventing from scratch later when the pressure is real and the clock is moving. First, don't rush. The instinct when there's an unexpected knock, especially one that feels official, is to move quickly, either toward the door or away from it, in a kind of panic. Neither of those is useful. Take a breath. Walk toward the door at a normal pace. Look through the peephole or a nearby window. Give yourself a few seconds to take in who's actually there and how many of them there are before you make any decision about what happens next. This is just gathering information, and gathering information costs you nothing. Second, understand that you do not need to open the door in order to have a conversation. You can speak through a closed door. You can crack a window if one is nearby and speak through that. And actually, speaking through a closed door, as slightly awkward as it might feel socially, keeps you in the strongest legal position throughout the entire encounter, because physically opening the door, and especially stepping outside, can change how courts analyze what happened and what the encounter actually was from a legal standpoint. If you want the maximum protection your home can provide throughout this interaction, keep the door closed and speak through it for as long as the conversation continues. Third, the first words out of your mouth, the very first question you ask before anything else, before any explanation of why you're not opening the door, or where you were last Tuesday, or what you may or may not know about anything, that first question is simply this: do you have a warrant? That question is not rude, it is not aggressive, it is not a declaration of hostility. It is the single most clarifying question available to you in this situation, because the answer to it determines which of two entirely different sets of rules applies to absolutely everything that follows. And it's a question officers expect and are trained to encounter, because anyone who genuinely knows their rights is going to ask it. So ask it, calmly, clearly, through the closed door if possible, the first chance you get to actually say something. Let's walk through what each answer means, because they lead down genuinely different paths, and you need to understand both of them. If the answer is no, there's no warrant. They're just here to talk, just want to ask a few questions, just want to follow up on something, just in the neighborhood, just have some concerns they'd like to address. Then you are in the simplest and cleanest version of this entire situation. There is no warrant. That means the entire encounter is voluntary from your side. Voluntary means you get to decide exactly how much of it you participate in, and the answer can be very little or none at all. Through the closed door, calmly and without hostility, you can say something like, "I appreciate you stopping by, but I don't consent to you entering my home, and I'd rather not answer questions right now. If you'd like to leave your contact information, I'm happy to follow up if I decide to do that." That is a complete response. That is a legally sufficient response that preserves every protection you have. And then you wait. Because here is what officers without a warrant will sometimes do at this point, and it's worth knowing in advance so it doesn't catch you off guard. They will often push back, not aggressively necessarily, but persistently. They'll say they just have a few quick questions. They'll say it will only take a minute or two. They'll say they're not there to cause trouble, and they just want to clear something up. They'll say everyone else in the neighborhood has been cooperative. They might say that refusing to talk makes this situation harder than it needs to be for everyone, including you. None of that changes the underlying legal reality even a little. None of it creates an obligation where none existed before. The right response to every version of it is some patient, polite variation of the same core sentence. "I understand, but I don't consent to entry, and I'd rather not answer questions right now." You can say it warmly. You can say it apologetically. You can say it with a smile in your voice. But the words need to stay consistent, because consistency is what makes it a clear, unambiguous statement that exists in the record of this encounter, rather than something that can be characterized differently later. One specific thing they sometimes say deserves its own moment. They might say that refusing to talk or declining entry makes it look like you have something to hide. This one carries a particular kind of social weight because it seems to be aimed directly at how you'll appear to other people, to officers, to neighbors, to anyone, and the instinct is to defend yourself against that implication by proving you have nothing to hide by cooperating. Here's what to say to that. I understand how it might look, and I'm not trying to be difficult, but declining isn't an admission of anything, and that's still my answer. You don't need to argue the point. You don't need to win the debate on your porch. You just need to repeat your position calmly one more time, because that's all the situation actually calls for. Now let's talk about the other answer, the yes, because this is where things get significantly more nuanced and where the most important details live. If officers tell you they do have a warrant, the next move is to ask them to hold it up to a window or slide it under the door so you can actually read it. Not because you're being obstructionist, because not all warrants are the same thing. What a warrant actually says and what kind of warrant it actually is changes everything about what you're required to do and what you're allowed to do and what you should say, and you cannot know any of that if you haven't actually read the document. So ask to see it before anything else happens. That's a completely reasonable request, and any officer executing a legitimate warrant should have no problem with it. There are two fundamentally different kinds of warrants that might show up in this scenario, and the distinction between them is genuinely important. A search warrant authorizes officers to search a specific location for specific items. A valid search warrant needs to be signed by a judge, not just written up by an officer. It needs to specify a particular address, your actual address, not a nearby address or a general area. It needs to describe with reasonable specificity what is being searched for and where. Within your home, officers are authorized to look for it. So if they're looking for a specific item that would fit in a drawer, a warrant that authorizes a search of the entire property, including the attic and garage, is potentially broader than it needs to be, and worth noting to an attorney later. But if you're looking at a document that appears to be a valid search warrant, signed by a judge, specifying your address, describing what they're looking for, then the legal reality is that officers generally do have the authority to enter your home to conduct that search, whether or not you personally consent to it. A judge has already reviewed evidence, found probable cause, and authorized this. That is what the warrant represents. Here is what you do when you're looking at what appears to be a valid search warrant. You do not physically block the door. You do not physically interfere with officers entering. Those actions don't protect you, and they can result in serious charges of their own that would otherwise never have existed. What you do instead, and this specific action carries real legal weight, is say clearly and calmly, out loud, in a voice that can be heard, "I don't consent to this search, but I understand you have a warrant, and I'm not going to physically interfere with you executing it." Say that sentence. Say it clearly, say it early in the encounter, and say it in a way that can be heard by multiple officers present, because that sentence does something important. It puts on the record that your compliance with the execution of the warrant is not the same as agreement that the warrant is valid, that the search was conducted properly, that everything officers do during the search stays within the bounds of what the warrant actually authorized, or that you waive any right to challenge any of those things later. You're preserving every challenge that exists through the proper channel for those challenges, which is a courtroom with an attorney, after the fact. That courtroom is where those fights belong. Your doorstep is not the place to have them, and trying to have them there in the moment is how people turn a situation that was manageable into one that's significantly worse. The second kind of warrant is an arrest warrant, and this is where the distinction that many people don't know about becomes critically important. An arrest warrant authorizes officers to arrest a specific named person. It is not a search warrant. It does not, by itself, generally authorize a full search of your home or your belongings. If officers arrive with an arrest warrant for someone they believe to be inside your home, they may, under certain conditions, have the authority to enter to locate and detain that specific person. But the arrest warrant does not give them the authority to start going through your drawers, your closets, your filing cabinets, or any other area of your home not directly connected to finding the person named in the warrant. These are two different things, and the difference between them has been the basis of significant legal challenges. So, if what you're reading is an arrest warrant rather than a search warrant, here is what you say. I see this as an arrest warrant, not a search warrant, and I don't consent to a search of my home. You're not saying this to start an argument. You're not saying it to prevent officers from entering if they have lawful authority to do so based on the arrest warrant. You're saying it to clearly establish, in the record of this encounter, that you understand the difference between what an arrest warrant authorizes and what a search warrant authorizes, and that you're not consenting to anything beyond the specific, limited authority of the document they've presented. Let's talk about what makes a warrant valid, because you need to be able to assess this quickly when you're actually looking at a document through a window or in your hand. A valid warrant is signed by a judge, not filled out by an officer, not stamped with a departmental seal, not signed by a supervisor, signed by an actual judge. A valid warrant specifies an address with particularity, meaning your specific address, not a vague geographic area. A valid search warrant describes what is being searched for and has some logical relationship between the items being searched for and the places officers are authorized to look. A warrant that's clearly for a different address, one where the street number or street name is different from yours, is worth pointing out. This warrant appears to specify a different address than mine. A warrant with no judicial signature is worth noting. I don't see a judge's signature on this. A warrant that's expired, if it has a date that's well past, is worth noting. You are not trying to win a legal argument in your doorway. You are creating a record of observations that an attorney can examine properly later, and making sure those observations exist somewhere other than only in your own memory. Now let's spend real time on a scenario that causes enormous confusion because it exists at the intersection of genuine urgency and legal complexity, which is the claim of exigent circumstances. Exigent circumstances is the legal term for an emergency situation that, under the law, can sometimes justify entering a home without a warrant. The genuine versions of this are specific and recognizable. Someone is screaming for help inside the home. There is clearly something actively on fire. Officers are in the middle of a chase and a suspect has entered the residence. There is credible, specific, immediate evidence that evidence is being actively destroyed in real time. These are real exceptions. Courts have recognized them. They exist because there are genuine situations where waiting for a warrant would mean the harm the warrant requirement is supposed to prevent would already be done. But here is the other side of that reality that you absolutely need to understand. Exigent circumstances is also one of the most frequently stretched justifications in Fourth Amendment litigation. The exception is invoked in situations where careful judicial review later finds it didn't actually apply. And the entire reason there is a robust body of case law around this issue is precisely because the courts are the place where the question of whether exigent circumstances genuinely existed gets examined properly, with full information, without the time pressure of a doorstep confrontation. So if officers claim exigent circumstances and move to enter your home, here is the move. You do not physically block them, because if circumstances genuinely are exigent, blocking entry has its own serious consequences. But you do say clearly and calmly, I don't consent to this entry. And you make that statement clearly enough to be heard, because that statement once made shifts the question of whether the entry was lawful to exactly the forum designed to answer it, a judge reviewing the facts afterward, where the full picture can be examined without anyone feeling cornered. let's talk about something that doesn't always get the attention it deserves, which is the legal difference between your porch and your home's interior, because the boundary matters in ways that many people don't realize until it's too late. Your home's interior is the core of the protection we've been talking about throughout this video. Your porch, your front step, the area immediately outside your door, occupies a somewhat different and more legally ambiguous space. Courts have recognized that officers can approach your door the same way anyone else can approach your door, because your porch is generally accessible to anyone who might come to visit. But the interior of your home, the space behind the door, is different. Here's why this matters practically. If you open the door and step outside to have the conversation face to face, you've left the strongest zone of protection and entered a more ambiguous legal space. If you step outside and then an officer steps inside your doorway while you're standing on the porch talking to another officer, questions arise about whether entry happened, how it happened, and whether consent was implicit in the way the conversation unfolded. None of those questions arise if you keep the door closed and speak through it from inside. I know speaking through a closed door for an entire police encounter feels slightly uncomfortable, maybe even rude. It is neither of those things. It is the exercise of a right you have, specifically so that the decision about what enters your home stays with you rather than drifting away in the course of a conversation that seemed harmless at the time. Officers who deal with people who know their rights encounter this regularly. Stay inside. Speak through the door. It costs you nothing in terms of the interaction and preserves significantly more than stepping outside would. Let's talk about consent carefully and specifically, because consent is really the center of gravity of this entire video, the same way it sits at the center of gravity of almost every conversation about rights and interactions with law enforcement. Consent has to be genuinely voluntary. Genuinely voluntary means you understood you had a choice, you understood what you were agreeing to, and you weren't agreeing because you felt like you had no option, or because you were mistaken about what was required of you. Consent obtained through implied pressure, through a misrepresentation about what officers are authorized to do, through a situation where someone reasonably believed they had no choice. All of that is the subject of challenges that courts examine regularly. And here's the piece that matters most practically. You are allowed to say no. You are allowed to say no even if you have done absolutely nothing wrong. You are allowed to say no even if your home is perfectly clean and there is nothing inside it that could possibly matter to any investigation. You are allowed to say no, even if saying no feels socially awkward and uncomfortable, and even slightly rude in the moment. Saying no is not suspicious behavior. Saying no is not obstruction. Saying no is you exercising a right that exists. Specifically so, this decision belongs to you, rather than defaulting to whoever is standing on the other side of your door. And every person who has ever wished, after the fact, that they'd said no at the beginning of an encounter that spiraled into something they didn't expect, was someone who understood intellectually that they could say no, but didn't, in the moment. Because the moment is specifically designed to make saying yes feel like the easier, more reasonable, more cooperative thing to do. Know this in advance. Say no when your instinct says no, and then let the system work the way it was designed to, with a judge. Not a conversation on your porch, as the thing that actually determines what happens next. I want to spend a moment on the emotional layer of this specific scenario, because it is genuinely different from a traffic stop or being approached on the street, and pretending it isn't different would be dishonest. Your home is supposed to be the place where you are most fully in control, most fully yourself, most fully protected from the external pressures of the world. A knock at your door from law enforcement disrupts that feeling in a way that is visceral and immediate, even for people who have done nothing wrong and have nothing to hide. That disruption is real, and it tends to produce a very specific kind of instinct, which is to resolve the discomfort as quickly as possible by being maximally cooperative, opening the door, answering questions, letting people in, hoping that demonstrating openness will make the whole thing end faster and better. That instinct is completely understandable. It is also the instinct most likely to cost you protections you were entitled to keep. The disruption you're feeling in that moment is not a sign that you should cooperate immediately. It's a sign that this is exactly the moment the preparation you're doing right now, right here in this video, was designed for. The version of you who has thought this through in advance, who knows what to say and why, who understands what they're protecting and exactly how to protect it, that version of you handles this calmly and clearly, and without feeling like they're improvising under pressure. That's what this video is for, not to make you adversarial, not to make you difficult, to make you prepared, So the version of you who handles this knows exactly what they're doing and why. Let me give you the specific words for several common scenarios, because a general understanding of the principles is useful, but what you actually need, the thing that will actually help you in the moment, is specific language you've heard before and can recall under pressure. When officers knock and simply say they'd like to come inside and talk, I appreciate you stopping by, but I don't consent to you entering my home. I'd rather not answer questions right now. If you'd like to leave your contact information, I'm happy to follow up. That's it. That's the complete response. You don't need to explain why. You don't need to apologize for it. You can say it warmly and you can mean it warmly, because you genuinely aren't trying to be difficult. You're just exercising your right to control who enters your home. When they say they just have a few quick questions, I'd rather not answer questions right now, but I appreciate you checking in. That's the complete response. If there's something that needs to be addressed, I'll handle it with an attorney's help. When they say refusing makes you look like you have something to hide, I understand that perspective, but declining isn't an admission of anything, and that's still my answer. Say it once, calmly, and then let the conversation sit wherever it lands. When they present a document and claim it's a warrant, could you hold that up to the window so I can read it? Or if they slide it under the door, take the time to actually read it before you say anything else. Once you've read it, the response depends on what you're actually looking at. If it appears to be a valid search warrant for your address, signed by a judge, with a reasonable description of what they're looking for, I don't consent to this search, but I understand you have a warrant and I won't physically interfere with you executing it. State that clearly. State it where it can be heard. If it appears to be an arrest warrant rather than a search warrant, I see this as an arrest warrant, not a search warrant. I don't consent to a search of my home. Say it clearly. Put it on the record. If something about the warrant seems wrong, a different address, no judicial signature, an expired date, this warrant appears to specify a different address than mine, or I don't see a judge's signature on this document. State what you observe, calmly, as an observation, not as a confrontational challenge. You're creating a record, not winning a debate. If they say they'll go get a warrant if you don't let them in voluntarily, that's completely reasonable, and I still don't consent to entry without one. This is actually, though it doesn't feel like it in the moment, a genuinely healthy outcome for you, because it means a judge, who has no stake in whether officers get to search your home, is the one deciding whether there's actually legal justification for it. That's the system working exactly the way it was designed to work. The discomfort of that moment is worth tolerating for what it actually represents. Let's talk about what happens in the minutes after officers leave, because this is a step a lot of people skip, and it ends up mattering more than they expected it would. As soon as the encounter is over, write down everything you can remember or record a voice memo right there, because memory is genuinely perishable, and the details that seem obvious and vivid right now will start to fade and blur faster than you expect. Write down the time the knock happened. Write down approximately how many officers were present. Write down what each one said, as specifically as you can remember it. Write down whether a warrant was shown, what kind it appeared to be, what address was on it, whether it had a visible judicial signature. Write down badge numbers or names if you caught them. Write down anything specific that was said about why they were there and what they were looking for. Write down exactly what you said and exactly how it was received. This record costs you 15 minutes at the most, and if anything about this encounter later becomes relevant, whether it's a question about whether consent was actually given, a question about whether the warrant was valid, a question about whether the search stayed within the bounds of what the warrant actually authorized, your own contemporaneous notes, created right after the encounter while the details are fresh, become genuinely valuable evidence. Doorbell camera footage, if you have it, is even better, because it creates an objective record of exactly what was said and exactly what happened that can't be disputed through competing memories later. If you have a doorbell camera, check that the footage is saved. If you don't, your handwritten notes are the next best thing. Let's talk about some specific situations that are connected to this core scenario but work slightly differently in ways that matter. Let's talk about Child Protective Services and welfare check visits from social services, because this is one of the most emotionally loaded versions of a knock at the door that exists, and it deserves specific attention precisely because the instinct to cooperate immediately and completely runs even stronger here than it does with police. The stakes feel higher, the implications feel more personal, and the social pressure to appear cooperative, to appear like a good parent, to appear like nothing whatsoever is wrong, can be overwhelming in a way that makes it especially difficult to slow down and think clearly in the moment. Here is the baseline to understand. In most places, a social services worker without a court order does not have the same legal authority as an officer with a warrant, and the general principle of your home being protected without your consent or a court order applies here too. Though the specific rules vary significantly by state, and the stakes of getting it wrong in this particular scenario are high enough that knowing your state's specific rules in advance, before you're ever in this situation, is genuinely worth doing. What you can say, calmly and non-confrontationally, when a social services worker appears at your door: "I want to be cooperative, and I take this seriously. I'd like to understand exactly what's prompted this visit, and I'd like to involve an attorney before we go any further, including before any interview or home inspection." That is not a statement that you have something to hide. That is a statement that you're taking the situation seriously enough to handle it properly, rather than on instinct in the doorway. If there is a court order involved, the same principle as a search warrant applies. Ask to see it, read it carefully, understand exactly what it authorizes, and comply without physically interfering while stating clearly what you do and don't consent to beyond its specific scope. Let's talk about process servers, because not every official-looking knock involves law enforcement at all, and it's worth understanding why this situation works a bit differently. A process server is there to deliver legal documents, a lawsuit, a subpoena, a court order, papers you're being legally required to receive notice of. The fundamental dynamics here are different from a police encounter, because refusing to engage doesn't actually prevent service from happening in most states. Process servers have alternative methods of completing valid service, like leaving documents at your door, with another adult in your household, or through other means depending on your state's rules. Avoiding a process server generally just delays things rather than preventing them, and in some situations the delay actually works against you if a deadline begins running from the date service was first attempted. This is a scenario where understanding what's actually happening and engaging with an attorney quickly is usually more strategically useful than treating it as a situation to simply not engage with at all. Let's talk about municipal code enforcement and city inspectors, because this is another category that often gets lumped in with police visits but operates under somewhat different rules. A city inspector with a clipboard showing up about a permit issue or a property code violation generally cannot enter your home without your consent or without an administrative warrant, which is different from a criminal search warrant but still requires some form of judicial authorization in most circumstances. The basic principle holds: ask what they're there for. Ask whether they have a warrant or court order if they want to come inside, and if they don't, you're not required to let them in simply because they carry a municipal badge instead of a police badge. "I want to cooperate with this, but I'd like to handle it through the proper process, including with my attorney involved if that becomes necessary," is a completely reasonable response that neither creates unnecessary conflict nor surrenders protections you're entitled to keep. Let's talk about welfare checks specifically, where someone is called because they're concerned about you personally, not about something you may have done, but about whether you're safe. This scenario deserves its own careful attention because it can produce a sense that being firm about your rights is somehow denying people who care about you the reassurance they were trying to get. Here is how this one actually works. If officers show up for a welfare check and you're fine, you can say so through the door, simply and clearly. "I'm okay, thank you for checking. I don't need anything right now." In the overwhelming majority of welfare check situations, that resolves it completely. Officers confirmed you're alive and coherent. The concern has been addressed, and the encounter ends. If they push for entry anyway, citing ongoing concern, you can say, "I appreciate you checking on me. I'm safe. I don't consent to entry." That statement matters because it creates a clear record that any entry beyond that point wasn't with your agreement, which is relevant if there's any later question about what happened and why. If there is a genuine specific reason to believe you're in immediate danger that can't be resolved by you speaking through the door, that's where the exigent circumstances analysis we discussed earlier would apply. But a general concern from someone who called in a wellness check without specific evidence of immediate danger doesn't typically rise to that threshold. Let's talk about what happens when you're not the one answering the door. If you live with other people, whether that's a spouse, a partner, a roommate, a family member, an adult child, then someone else might open your door in your absence without fully understanding what's at stake in that interaction. This is worth addressing directly and specifically, in a calm conversation that happens well before any encounter ever occurs, not as a warning or a lecture, but as practical information they genuinely deserve to have. You are not obligated to let anyone in without a warrant. You are not required to answer questions. Declining to do either of those things is not illegal and is not suspicious. And if you're ever uncertain about a situation at our door when I'm not here, just say you'd rather not discuss anything right now, and we can follow up later. The instinct to be helpful, to be cooperative, to be the kind of person who makes things easier for everyone, doesn't disappear because someone is answering a door that isn't primarily theirs. Make sure the people you live with have the same foundational understanding you're developing right now, because an encounter that happens when you're away and you weren't there to navigate it is one you can't manage from a distance after the fact. Let's talk about roommates and shared living situations with an additional layer, because this is where consent and authority to consent get specifically complicated. In a shared home, a roommate can generally consent to a search of common areas that you both use, like the living room or the kitchen, even if you personally would have refused. This is sometimes called third-party consent, and courts have recognized it in situations where the person consenting has genuine common authority over the shared space. But this generally does not extend to areas that are specifically and exclusively yours, like your own locked bedroom within a shared apartment. Your own locked, private space within a shared home typically requires either your consent or a specific warrant that covers that specific area, even if your roommate has consented to the rest of the search. If you're ever in a situation where you're in a shared home and the question of consent comes up, stating clearly that you do not consent to a search of your specific private spaces, even while a roommate is cooperating with a search of shared areas, creates a record that matters. Let's talk about landlords, because this is a misunderstanding that comes up more often than you'd expect. A landlord does not have the authority to consent to a search of your rented unit on your behalf. The expectation of privacy you hold in your rented apartment or rented house during your tenancy is yours, not your landlord's. A landlord can show police to the building, can let them into common areas, can speak with officers, but consenting to a search of your specific unit, the space you have leased and hold a reasonable expectation of privacy in, is not something your landlord has the authority to do in your place. If officers arrive and claim your landlord has consented to a search of your apartment, that claimed consent is not the same as a valid warrant, and you can and should state clearly that you do not consent to the search of your unit, even if your landlord has said something different. Let's talk about something worth sitting with specifically, because it's a scenario that catches people completely off guard. What if you've already made a mistake? What if you already opened the door before you knew any of this? What if you already answered questions, or already let them in, or already said something you wish you hadn't? And now you're somewhere in the middle of an encounter that has moved past the starting point you would have chosen if you'd known then what you're learning now. First, don't panic, because panicking leads to filling silence with words, and words are the one thing you want to be very careful with right now. Second, don't try to walk back or explain what you already said, because that almost never works the way people hope, and often adds more confusion to an already complicated situation. Third, and this is the part that matters most, even in the middle of an encounter, even if it's already been going on for a while, you can stop. You can say, "I'd like to stop answering questions now. I don't consent to anything further from this point forward. I think I'd like to speak with an attorney." Those sentences are available to you at any point, not just at the beginning. The right to remain silent doesn't expire after you've already said a few things. The decision to stop engaging is available whenever you make it, and making it later is still significantly better than continuing to make it never. Let's talk about a related scenario that deserves its own moment. Officers who are already inside your home for a legitimate reason. Maybe you called them because of an emergency. Maybe you let them in to report something. Maybe the initial reason for their presence was entirely unrelated to anything about you. And then partway through the interaction, something shifts, and you start to feel like the conversation is moving in a direction you weren't expecting and aren't comfortable with. The same principles still apply even when officers are already physically inside. If they entered with your permission in the first place, you can withdraw that permission. You can say, "I appreciate your help with the original matter, but I'd like you to leave now, and I don't want to continue answering questions." You can say, "I think I need to speak with an attorney before this conversation goes any further." These are available to you mid-encounter, not just at the beginning, and using them doesn't mean you've done anything wrong. It means you're navigating a situation that has developed beyond what you initially expected, and you're handling that development appropriately. Let's talk about recording, because it's as relevant here as it is in any other encounter with law enforcement, maybe more so given how much can turn on the specific words used and the exact sequence of events. In most jurisdictions, you're allowed to record an encounter with police at your own front door. You have an even stronger argument for recording within your own home than you do for recording on a public sidewalk, because this is your private property and you have a broad right to document what happens on it. A doorbell camera that's running automatically is already doing this for you, without any decision required in the moment. And if you have one, it's one of the most practically valuable tools you can have for exactly this kind of situation. If you're recording on your phone, you don't necessarily need to announce your recording, though some states have specific rules about this that you should know in advance for your jurisdiction. The record created by a recording, objective, time-stamped, capturing exactly what was said, rather than relying on competing memories, is genuinely valuable in any situation where the details of an encounter later become relevant. Let's talk about something practical that applies to all of this, which is that the best time to understand any of it is right now, not in the moment it's actually happening. The moment the knock comes, the moment you see the uniform through the peephole, is exactly the wrong moment to be reading about your rights for the first time. It's the wrong moment to be piecing together a vague memory of something you once heard about warrants and consent. It's the wrong moment to be improvising responses to a situation you've never thought through before. The right moment is now. This video, a calm afternoon, a time when there's no need. Before I let you go, I want to say one more time that understanding your rights clearly isn't a small thing, even when the specific topic feels minor on the surface. It's the difference between navigating a real situation with confidence and navigating it with anxiety and guesswork. And that difference matters more than people usually realize until they're actually standing inside a moment where it counts. Thanks for spending this time building that understanding with me today. I'll see you in the next one.